Welcome to the 31st lecture of this lecture series on international arbitration practice. This lecture is a part of chapter 2 on invoking arbitration in international commercial arbitrations and international investment arbitrations. In this lecture, we will deal with the 8th and the 9th part of the 12-part checklist. The topics would be authorization for request for arbitration and aspects relating to the arbitration and language. Item 57 of the checklist is: if a claimant is a juristic entity, necessary authorizations have been obtained from its board for invoking arbitration. This requirement is based on Rule 2(1)(f) of the ICSID institution rules. Recollect that there are broadly two rules that are applicable to ICSID arbitrations. One is the ICSID institutional rules, which deals with procedures and the requirements for instituting a request for arbitration or conciliation, and then ICSID arbitration rules, which deals with the procedure for conducting the arbitration. Now, Rule 2 of the ICSID institution rules deals with the contents of the request, and Rule 2(1)(f) states the request shall, if the requesting party is a juridical person, state that it has obtained all necessary internal authorizations to file the request and attach the authorization. Now, coming to the notice of arbitration in Discovery LLC vs. Slovakia, the relevant portion of the notice of arbitration covers this item of the checklist and states 104. Pursuant to Rule 2(1)(f) of the institution rules, which requires the requesting party, if a juridical person, to take all necessary actions to authorize the request, the claimant affirms that it has taken all necessary actions to authorize this request. The claimant has also duly authorized Signature Litigation LLPs to submit this request for arbitration. So here the authorization is twofold. The first is to submit the request and invoke the arbitration, and the second is to authorize the law firm to submit the request of arbitration on behalf of the claimant. While this is more explicit as regards compliance with the requirements of Rule 2(1)(f), the arbitration notice in CR Northstar vs. Norway states the same thing but without reference to the said rule. It states 12. Northstar has taken all necessary internal actions to authorize this request for arbitration. Northstar's board has considered the matter and issued a resolution authorizing consent to arbitration and execution of the instruments necessary to make this request. Noticeably, the CR Northstar notice also exhibits the copy of the board authorization in the following manner: Northstar Board Resolution authorizing claim 3 February 2020, it's at C49. The next part of the checklist relates to certain arbitration related aspects. Item 58 of the checklist relates to the number of arbitrators. To provide some background, Rule 3 of the ICSID institution rules deal with the recommended additional information to be contained in the request for arbitration. Rule 3A1 recommends the request to contain proposals or agreement between the parties relating to the number of arbitrators. It states it is recommended that the request contain any procedural proposals or agreements reached by the parties, including with respect to 1. The number and method of appointment of arbitrators or conciliators. Item 59 is closely related. Appointment procedure for arbitrators. Usually each party appoints one arbitrator. These are usually specified in the relevant BIT. To illustrate, the notice in Discovery LLC states as regards the number of arbitrators and the procedure for appointment as follows. 105. Article 7(2) of the BIT provides as follows. Within 2 months of receipt of a request, each party shall appoint an arbitrator. The 2 arbitrators shall select a third arbitrator as chairman who is a national of a third state. 106. The claimant proposes that this method is followed, that the tribunal consists of 3 arbitrators with 1 arbitrator by the claimant, 1 appointed by the respondent, both within 2 months of receiving the request, and the presiding arbitrator to be appointed by agreement of the two party appointed arbitrators, failing which the presiding arbitrator shall be appointed by the chairman of the Administrative Council of ICSID pursuant to Article 38 of the ICSID Convention as soon as possible, and in any event no later than 90 days from the date of notice of registration of the request. The respondent is hereby invited to respond to this proposal within 20 days from the date of this request in accordance with Rule 2.1b of the ICSID arbitration rules. Part 10 of the checklist relates to language. Rule 3A2 of the ICSID institution rules recommends that the request for arbitration contain the additional information relating to the language of arbitration. It states it is recommended that the request A contain any procedural proposals or agreements reached by the parties, including with respect to the procedural languages. The notice in Discovery LLC states in this regard 108. Pursuant to Rule 22.1 of the ICSID arbitration rules, the claimant proposes that English be used as the procedural language of the arbitration. Note that the reference to Rule 22.1 of the ICSID arbitration rules is that of the 2006 rules and not the 2022 rules. Rule 22.1 of the ICSID arbitration rules 2006 stated 1. The parties may agree on the use of one or two languages to be used in the proceeding, provided that if they agree on any language that is not an official language of the center, the tribunal, after consultation with the Secretary General, gives its approval. If the parties do not agree on any such procedural language, each of them may select one of the official languages, that is English, French and Spanish, for this purpose. This provision is now reflected with some changes in Rule 7.1 of the ICSID Arbitration Rules 2022. It states the parties may agree to use one or two procedural languages in the proceeding. The parties shall consult with the tribunal and the Secretary General regarding the use of a language that is not an official language of the center. If the parties do not agree on the procedural languages, each party may select one of the official languages of the center. That's all in this lecture. More in the next one. Bye bye and stay safe.